Well, hello everyone. It was a great morning. It threw up some interesting themes, and of course we're going to carry on with some of those themes at this next session, which is specifically discussing online dispute resolution. And we are very fortunate to have such an international panel assembled here, and we are very fortunate that we will be able to learn from their experiences, their mistakes as well as their successes as we embark on our own ODR journey. I'd like to introduce myself firstly. My name's Keryn Negri. I'm the CEO of the Victorian Civil and Administrative Tribunal. The Chief Justice mentioned this morning that we do around 90,000 to 100,000 matters a year. Our main customer base or our main client base are self-represented litigants. Around 80% of people who use our services represent themselves. The Victorian Civil and Administrative Tribunal is ripe for online dispute resolution. And like all funded, government-funded agencies, we're under enormous pressure to deliver high-value services at lower cost. And in the main, we're looking to modern technology to enable us to do that. And as we watch other services in the economy become sleeker, cheaper, faster, much more customer and client-centric, and easier to use as they embrace and adapt to new technologies, the legal environment seems to be lagging behind. And as CEO of a dispute resolution organisation, keen to be a national and international leader and to fully embrace the term an e-tribunal, this transformation is sometimes depressingly slow. Poor existing IT infrastructure, ad hoc and short-term funding commitments, and significantly that resistance to change and that reluctance to adopt new ways of doing business that we talked about at this morning's session all means that the legal sector does not often get described as early adapters. Online dispute resolution is still very much a concept here in Australia. However, it's with great excitement that the Victorian Government, in the recently released Access to Justice review, has signalled a strong willingness to support the development of an ODR system for small civil claims. And it's a great opportunity for VCAT to be able to partner with the Department of Justice and Regulation and other key stakeholders, notably the Dispute Settlement Centre Victoria and Consumer Affairs Victoria, on this important initiative. And as we embark on our ODR journey, we are tremendously lucky to be able to learn from the international experience, and that's what this session's all about. The format today is pretty straightforward. Each of our panellists will have an opportunity to provide a brief presentation, and I intend to leave as much time as possible for your questions. So I'll be jigging them along and winding them up after their 10 minutes is up. So without any more waste of time, I'll introduce our special panel. We've already met Shannon Salter, Chair of the Civil Resolution Tribunal in Canada. I don't need to go through your credentials again, and as we learnt this morning, we can all Google that. I'd also again like to welcome the Honourable Judge Dory Reiling, and of course we heard all about her credentials as well, so I won't go over that again. Just to say that one of Dory's key themes in a lot of her published work is how advances in technology can create greater access to justice for those who currently do not have access, and I'm sure we'll touch on that theme today. I'd also welcome virtually Colin Rule. Hi, Colin.
Hi, everybody.
Colin is the chairman of Modria.com. We're beaming him in from Silicon Valley, where I understand it's about 4:30 on the eve of the election. Have I got the day right? It's Monday?
Today is Monday and the election is tomorrow. So you guys, since it's already Tuesday, how does the election come out?
We'll keep you up to speed as the results come in, Colin.
Sounds good.
So, as Director of ODR at eBay and PayPal, Colin has been developing ODR tools since 2003. He's a fellow at the Gould Centre for Conflict Resolution at Stanford Law School and works closely with the National Centre for Technology and Dispute Resolution at the University of Massachusetts. Both Canada and Netherlands have worked closely with Colin and his company, Modria. We were lucky enough to have Colin out here in August, so it's great to see you again, Colin. Albeit I can't see you because you're actually behind me, but that's okay, I'm dealing with that.
I think I can touch your head.
He could be doing this to me and I wouldn't even know. Finally, I'd like to make a very warm welcome to Michele Griessmair, and I do hope I've done justice to your name, Michele. Michele has, no, I knew I wasn't going to, but anyway. Michele arrived in Australia yesterday from Vienna via India, so he's come a long way to be with us today. He's here for a 12-month research fellowship with Victoria University, and today he's going to talk to us about computer-mediated communication and dispute resolution. His research seeks to answer the question, is computer-mediated dispute resolution better or worse than face-to-face mediation? And probably a lot more besides. Anyway, can you please make our guests welcome? Also, make a note of your questions as you go, so you're ready to put up your hand when we hand over to questions. But I'll start by inviting Sharon up to the podium.
Well, hello again. My 6-year-old daughter always jokes that all I want to talk about is tribunal, tribunal, tribunal. Always about this tribunal. So needless to say, it's a real pleasure to be asked to speak about it twice in less than an hour and a half. Thank you. My daughter thanks you because it just means an extra 10 minutes. I won't be talking about it later on with her. So I'm back again. So we had a little talk earlier about, well, a big talk about change. But some of you might be wondering, well, what was this change all in aid of? What were you trying to do? So this 10 minutes is meant to give you a very rough overview of what the CRT is. And as a starting point, the CRT gets a lot of attention for being online. And that's not a bad hook to engage people. But really, it's about access to justice. And it's about people. And so one of the things that I think is equally, if not more important about the CRT is this idea that you build it around people, that you give people choices about how to resolve their disputes, that you give them every opportunity to resolve their disputes consensually because evidence shows that's better for them and more satisfying. And so how do you do this? How do you bring the justice system to people? How do you give them those kinds of choices? Well, that's where technology is helpful. But we don't worship at the foot of our computer. We use it as a useful tool wherever it makes sense to achieve those bigger goals, which is to achieve a human-focused part of the justice system. And so that's what we try and keep our eye on as we go with implementing the tribunal. So I won't go into too much detail because it's not that interesting to an international audience, but we have 2 buckets of jurisdiction at the CRT. One is over what you would call owners corporations, stratas, what we just call stratas in BC. And roughly half our population in British Columbia either owns a strata, rents a strata, or works out of a strata. So it's a huge part of our population, and until July 12th of this year, anybody who had a dispute, a neighbor dispute, had to go to our superior court to have it resolved. At a cost of what our strata lawyers tell us is between 25 and 35,000 Canadian or Australian dollars, because they're on par basically, to resolve. So a massively disproportionate way to resolve these very low-level neighbor disputes, which span all these things you see here, tussles over shared living space. As of 3 months ago, those disputes now on a mandatory basis come to the CRT, aside from the more land-based ones, where you're actually disposing of the interest in land. As I mentioned earlier, we anticipate that in about 3 or 4 months, the parts of the Civil Resolution Tribunal Act giving us jurisdiction over small claims will also come into effect, again on a mandatory basis. Ultimately, that will be claims under $25,000, but we're going to start off smaller. That was part of what I was discussing about implementing in stages. So we're likely to start off with claims under $5,000 and then move on from there. So that's what we're dealing with. But how are we going about doing this? I think it's worth pointing out that as a strategic decision, it's not a bad place to start picking these owners, corporations claims and small claims as a way to experiment with ODR. These are two areas where there's a pretty high pain point in the justice system. Having to go to superior court for the strata claims and having to deal with delays of up to a year for small claims. But at the same time, nobody's living or dying with these disputes, right? They're important to the people who are affected by them, but nobody is going to be imprisoned if there's some sort of systemic failure. It's a good place to start, and it's a good place to experiment. So we've developed some key guiding principles with the CRT, and everything that we do has to drive towards these principles, because we've concluded that if you're really honest about wanting to design around the needs of the public, you have to have these goals in mind. And wherever possible, we've used empirical evidence to formulate these. One is focusing on early dispute resolution, because data shows that the longer somebody has a civil justice claim, the more it negatively impacts their mental, physical, and financial health. So we aim for a 60 to 90-day resolution period. We offer people a flexible range of dispute resolution mechanisms, but we are also trying to stay flexible ourselves through user testing so that we don't get too arrogant, frankly. The CRT now is available 24 hours a day, 7 days a week, anywhere where there's an internet connection. The front end of it is free. It's something I'll be demonstrating in the masterclass later this week, and it's something you can go and have a look at yourself if you're interested. And then the rest of it you can still engage with on an asynchronous basis. So as it turns out, we know, because we've opened now, 40% of people file their application outside of typical working hours, the hours that court registries are open, which isn't surprising, but it does validate the idea that flexibility and accessibility is key. The cost is roughly what our small claims court costs, so there are user fees, but they're nowhere near the legal fees or even the court cost fees you'd have to pay to go to superior court. And we've also designed a very generous fee exemption system for people who are low income. And last but not least, we're really focused on efficiency, tailoring timelines and processes based on good analysis of dispute types. That's something we'll get better at over time as we understand dispute types better and can tailor processes that we know are most likely to work for them. So those are our principles. Here in a snapshot is how it will actually work. Typically in Canada, the United States, and I think it's true in Australia and England as well, 98% of civil cases don't go to trial. Only 2 to 3% go to trial. The other 98%, we tell ourselves as lawyers, tend to settle. We're like, oh, it's okay. All this process we've built out around litigation causes people to settle. But there's some burgeoning research that shows that that's not true. And about half of those 98% of cases go away because of attrition. People give up. Because they can't navigate these barriers of cost and delay and time off work and childcare. So if you know that you're not meeting the needs of half the people who bother to take the time to file the paperwork in the first place, I think that begs some serious questions. So one of the things that we're trying to do is flip that model. If we know that only 2 to 3% of people will actually need an adjudication or make it to that stage, then why build the entire system around adjudication? Which is what we've done in particularly the common law justice world, right? Every step you take from filing your paperwork all the way to the end is built around this assumption that you'll get a trial, an assumption that's not true 98% of the time. So by flipping that model, focusing on early dispute resolution, we can build our system around what we know people are likely to need, which is early consensual dispute resolution. So that's where most of our resources are. That's where we think 80 to 90% of claims will settle with the assistance of facilitators and professionals. The front end is something called the Solution Explorer. It's a guided pathway system. It's meant to give people free legal information and tools to resolve the problem themselves. That seems to be bearing out. So in the 3 months that we've been accepting claims, we've had about 2,500 people go through the Solution Explorer, this free interactive question and answer pathway. And they are printing out things like template letters to send to their owners' corporation councils to ask for hearings to resolve their dispute themselves. A much smaller subset of those people have actually gone on to file claims, only about 120 cases so far. So that's good. We want people to be able to resolve their dispute themselves without ever needing us, much less a court. So we're doing some deeper analytics to make sure that that's actually what's happening and it's not for some other reason. But anecdotally, so far, that seems to be what's going on. We offer mail and telephone-based service for people who can't use online technology, but the assumption is that people will provide an email address, and that's how they will mostly communicate with both the tribunal and the other parties. So far, we've had only 2 people out of the 120 plus all the respondents, so roughly 250, 300 people. So out of 250 or 300, only 1 or 2 have asked to use mail instead of email. So it's early days yet, and definitely a very small sample group, but an early indication that our earlier work to research internet use has been validated, and that people are primarily comfortable with online service. So here's some snapshots I'll guide you through really quickly with the time I have left to show you how this actually works. This is our homepage, and you're welcome to follow along on your phone if you'd like to. It works just as well on a smartphone. And you click the Getting Started button. That takes you, after a few more screens, I'm really doing this in a very truncated way, to some questions and answers. So somebody would indicate whether they're an owner or a tenant or a strata council. And based on their answer to questions, we give them bite-sized bits of plain language information. Everything that we've created is meant to be at a grade 6 reading level, because that's what evidence says you need to write at in order to make health or legal or any kind of information generally accessible to the public. And we know lawyers aren't always good at this, so we hired plain language experts to help us with this, and content writers. We don't always achieve that. There's definitely room for improvement. So people can tell us if a question is missing, their issue isn't here, and that information helps us build this out further. We have a progress bar so they know how long they're in for this whole thing for. People like to know whether they're signing up for something that's going to last an hour or 15 minutes. And they can also ask us a question by using the help button. So we ask questions, we give people tools like this. It's actually 1 and a bit page document about a rental issue, for example. People can rate this through a star rating system. They can also hit that very cathartic not helpful button. This is the kind of information that we get and review weekly to know if this is a dud and we need to revisit it. And we do that very frequently. We have weekly change meetings to assess that. This is an example of the tool I was mentioning. So these template letters are pre-filled out. They already have the right sections of the Act, and they're based on people's answers to certain questions. The person can print this out, send it to their neighbor or somebody else they have a dispute with, and hopefully resolve the dispute consensually. Because people tell us that oftentimes they don't feel like they have the information or the knowledge to be able to write the letter themselves. So that's a very popular tool. Just a quick pitch that this is responsive. So information that goes through the Solution Explorer is anonymous. We don't collect personal information at that point. But at the end of that exploration, somebody can choose to start a claim. But it's at that point that we already know which form they need. They've already told us, for instance, they're a strata owner, so we don't give them the form for an owner's corporation. And so it's seamlessly integrated. We also built it to work primarily for mobile phones, because that's the way to create the most accessible technology for most people. So our low-income stakeholder or advocates for low-income individuals tell us that if you're going to build technology, it better work on a smartphone, because for their clients, that's often the only technology they'll have in their house. Really briefly, in the time I have left, just a recent snapshot of some of our user testing. This is the 7th or 8th round. If you're wondering why it's just a 3-week period, we've done a lot of these, and the numbers are pretty consistent. So this is the last bit of beta testing we did before we opened our door in July. And it's really just to validate, I think, or I think it validates the idea that frequent beta testing, frequent user testing yields results, which is that people's expectations of how things will work aren't wildly disproportionate to how they actually work. These are not numbers that typically are associated with government-type IT projects, at least in BC. Okay, so with that, I will hand it back, and I hope I'm not over time.
No.
Okay.
That's totally fine. Thanks, Shannon. Dory, I'm going to hand over to you. You still here?
Listening to Sharon, I would like to show some pictures.
Fine.
They're on here, so it'll only take me a second to...
Dory's just going to load up a PowerPoint presentation.
Pictures work so much better than just hearing someone talk.
While we're waiting for Dory's PowerPoint presentation to be loaded, does anyone have a question they'd like to throw to Shannon? I've got one. Oh, good.
Dan has one.
Shannon, how did you go about finding your groups of ever-increasing circles of trust? So presumably you started with friends and family, I know that. How did you find the next group and the next group and the next group?
Right, that's a great question. So we have a number of working groups that are built with stakeholders from different organizations. So for instance, owners, corporations, associations, the bar, different groups, bar associations, the Law Society, mediators, lawyers who work in the area, and they serve on our working groups. And so we consult them fairly regularly. These are not people who are rabid supporters necessarily of the CRT, but they are people that we've built trusting relationships with. And so all that our ministry needed to know was that they were not going to be running off to the media the first time that they saw technology that was in its infancy, and they had confidence that these people wouldn't do that, but that they would provide honest feedback. So we started internally. We started with our own families and friends and internally, and then built outward from that. So it's just one example, but the circle kept getting broader and broader until it's just a wide open public beta. And I think Dory's ready.
Off you go, Dory.
Okay. Thank you for your patience. I think it's just better to give you some visual information as well. The first question Keryn asked me was, tell us a little bit more about the project you're working on at the moment now. My project is part of a program that is a joint Judiciary Ministry of Justice program called the Quality and Innovation Program. And of course the aim of that program is to improve the quality and innovation in the courts. It requires new legislation. And for my project, which is the Civil Justice Project, the law of civil procedure was completely overhauled. That was a lengthy process, and we were already designing the system. Meanwhile, the law was being changed, so we had to redesign when there were changes in the law that were relevant for our procedure. The administrative procedural law was already much more modern. That didn't require quite so much change. There are a couple of other legal instruments that are important, and for us the most important was the group within the judiciary designing the new work processes. We're doing 4 installments, and the one I'm working on at the moment is the claims procedure with compulsory legal representation. That's claims over 25,000 euros. And afterwards, there will be a couple more. We'll do appeals, and then we will do self-representing litigants. Personally, I think that's going to be the most interesting one, but it'll take a while before we get there. And then requests, which are also, a lot of them are self-representing and mostly family law. And finally, there will be a small project for summary proceedings. Now, from my research on what makes successful projects, rule number 1 is to keep things simple. And we do that in a number of different ways. Way number 1 is that we use a methodology called agile software development, and I'll talk a little bit about that later. What it involves is saying, all right, we first build a happy flow, everything goes well, there is one party on each side and everybody does what they're supposed to do, no exceptions. We build that first, and if that works, we start building in. We have proof that we can do it, and we start building in exceptions. And from day 1, we test with users. We have had fantastic user groups. From day 1, we've also tested with lawyers, their end of the procedure, and that has worked really well, and also built kind of a confidence base within the bar that we were involving them and getting it right. So the heart of agile software development is a user story, and a user story describes what a user needs to be able to do. We do not ask what the system can do and then we build that. We don't care. Systems can do most things. The important thing is to think what you want them to do. So as a lawyer, I want to file a complete defense so the judge is properly informed. That would be a kind of a user story that we work with. And for each and every activity, we have a user story like that. And my project now has about 2,500 of them, most of which we've actually built. So that is how that works. A little bit about the technology that we use. It's fairly standard. We have a central architecture. So for the whole of Holland, there is one server park and one address that you go to. We use for the databases, we use the Oracle database suite, mostly because we were already using it, and we kept it. And we're using components that Oracle provides on top of the database. So service-oriented architecture, those are programs that do things for you. They get information from different sources and present it to you. The most exciting part is adaptive case management. That is a way of designing our digital case management system that is flexible enough for exceptions to be used whenever they're necessary. So the process itself is not a straitjacket that you can't get out of, because at any time you can do something that the system wouldn't itself do. And for the portals, we have a portal for e-filing forms. We use Microsoft.NET technology for that. We also have the option of a systems interface for large law firms where they can directly plug into our system and send us the data from their system directly without using the web portal. And our new procedure is a complete digital transaction. So it's not just e-filing and then nothing. It's e-filing, and then you pay the court fees digitally. Case management is digital. There is a digital case file that everybody has access to 24/7. The only thing that is still face-to-face is the hearing. And we are keeping that because we have discovered how important face-to-face hearings are. The end product of a procedure is a digital document that is signed digitally and that's also archived digitally. So everything is digital except the face-to-face hearing. How much more time do I have?
1 more minute.
1 more minute. Okay. This is what the procedure looks like, and I'll walk you through very quickly. A lawyer files a claim. The system immediately makes a case file and gives the case a number, and within about 10 seconds, you have access to your digital case file as a lawyer. Involving the defending party is the third step, and if the defending party decides to file a defense, they are given a term to do that by the case management system automatically. Meanwhile, the court has done some administrative preparation, but not a lot because the system actually does most of that. And at the same time, the judges and the clerks can start preparing for the hearing. The hearing is face-to-face. Document production is, of course, completely digital. And at the end of the procedure, the parties get a notification that there is a new document in the case file, and that obviously is the court decision. And all the time, they can consult the case file, they can send messages to the court sends messages out to them, and they can upload documents. So that's the lowdown on the procedure that is, as we speak, going live. So I keep an eye on my mailbox in case something goes wrong, but so far nothing has. Things are going fine, and that's a great relief, I must say.
Dory, could you have done it without the overhaul of the civil procedure legislation?
Yes and no. On the one hand, the original plan for the overhaul of the procedural law was much more ambitious, but it turned out that the legal community wasn't ready for that kind of radical overhaul. So the law as it is now is much more complex than I would have liked it to be. Mm-hmm. And that complexity has meant that we've had to build a lot of things that I would rather not have built. Mm-hmm. So that's, I'm not sure if that's the yes or the no part.
Well, I'm curious as to how much change you can drive without changing the law. And I think it's probably the same with the establishment of CRT. You couldn't have done that without legislating for it.
I think you can under our common law in the sense that administrative tribunals have a great deal of flexibility in terms of choice of procedure, but it certainly helps to make it explicit, particularly to the legal community, that no, that's what the tribunal's authorized to do and that's the way it's authorized to do it.
We're going to hand over to Colin now. And Colin, I was just going to start off by asking you a question. Given you've worked directly with courts and tribunals to introduce ODR systems, what are some of the recurrent barriers you face, and how big is the change, and how great is the resistance?
Well, I will tell you, it's actually quite great. I would say 75% of the challenge in launching a system like this is organizational resistance to change. I think people are used to doing things a certain way, and when you bring in technology, you can do a lot of amazing whiz-bang things with it, but obviously there are people that have been working in these systems for dozens of years, and they're used to things going a certain way. So we've gotten to the point where we can launch our system in a couple weeks, but it still takes 6 to 8 months oftentimes to launch the system just because of the resistance that's encountered internally within organizations. So we can talk about that more in the Q&A. Should I dive into the slides here, Keryn?
Yeah, go to it.
Okay, great. So, we've talked a little bit about kind of what online dispute resolution is. I prefer a very big umbrella for what ODR is. I think online dispute resolution is the use of information and communications technology to help parties resolve their disputes. Now, obviously, we're doing some pretty whiz-bang stuff here. I would love to be there with all of you in Melbourne. It's one of my favorite cities, but it's cool to be here in Cisco World Headquarters, beaming in via telepresence. I think it's oddly appropriate for this panel. But other technologies like the telephone is an information and communications technology. There's a lot of powerful things you can do with easily accessible technologies like the telephone or an LCD projector. So I was the director of online dispute resolution at eBay and PayPal. And if any of you have used eBay and PayPal, we have something called the Resolution Center. Any user of eBay can go to their personal resolution center and report a problem. And at eBay and PayPal, we got 60 million disputes per year, which actually is in excess of the US court volume. And we got to the point where 50% of those could be resolved amicably, and 90% of those disputes were resolved in software, meaning no employee of eBay had to touch that case. And this was an entirely extrajudicial process, but 99.999% of these cases were never appealed to a court. So what we found at eBay was the legal system was actually pretty irrelevant to these cases. They're low value, they're cross-border, the jurisdictions are confused, and our users demanded one-click resolutions. We found people would rather lose their dispute quickly than win their dispute and have it take a long period of time. And based on our analysis, that long period of time was 12 days. If the resolution process took longer than 12 days, people wished that they had never bothered to file the dispute in the first place. And the satisfaction was higher for people that lost in 1 day than people who won in 12 days. So I am not, the courts are not set up to deliver outcomes in 12 days, but we knew we needed to do that. So eBay paid a lot of money to build these systems because we knew we needed to provide fast and fair resolutions to our users all over the world. So I am not a lawyer, actually. I'm what they call a non-lawyer mediator. I'm very focused on just the dispute resolution aspect of this. So I believe that ODR works more the way the internet works. You don't have to worry about jurisdiction. You just build redress directly into the place where the dispute arose in the first place. And the other thing is that you can automate this process largely through software, which generates enormous efficiencies. So what we're seeing all over the world, and I'm not going to go through this in much detail, is international organizations are coming to this same conclusion. And I think what you're seeing in the Netherlands is a great example of what you're seeing with the Civil Resolution Tribunal in BC. UNCITRAL, the UN agency responsible for harmonizing global laws, has had a working group on ODR for several years. The UK is now talking about launching an all-online court for low-dollar civil volumes. So I think this is really where the future of justice resides. Now, there are a lot of different areas where ODR is relevant. We can talk about it in the legal services area, and that's what we're focusing on today. But obviously ODR came out of e-commerce. And if you look at the volume that Alibaba and that Amazon and that eBay are doing, that's in payments, marketplaces, and merchants. But we also are the #1 processor of property tax assessment appeals in the United States. So we're resolving disputes over people's tax bills. We're doing insurance cases. We run the largest case volume for the American Arbitration Association, which is a no-fault insurance volume. But we're also working in product liability. We're working with consumer protection organizations. We're working with ombuds offices and also the UK Civil Aviation Authority. We run all the disputes that consumers file against airlines there. And then also we're doing a lot of work with courts. But if you put on the ODR glasses, you start to see dispute volumes everywhere. And what's exciting is there's so much innovation that's going on. So we're doing a lot of work in legal services. We're working with Consumer Protection British Columbia, with Consumers International. There's a lot of exciting stuff that's happening in the US. But mainly what Modria is it's a toolbox for building dispute resolution processes. It's security certified, it lives in the cloud, we can host it anywhere in the world, but fundamentally it's about delivering efficiencies and delivering the kind of resolution process that consumers and citizens want, which is very streamlined. So we talk a lot about the diagnosis, negotiation, mediation, and evaluation chain. And you can think about these as Legos. And based on the type of dispute that you have, you can click the Legos together to, as we say in dispute resolution, fit the forum to the fuss. So I'm just going to quickly go through a couple things and I'll show you a couple screens and then we can get to the Q&A. But this notion, and I think Shannon talked about this very persuasively, technology can get access to disputes before the complainant has even notified the respondent that there's an issue. So being able to set expectations and enabling them to educate people about what their rights may be, that's enormously powerful. And you see a lot of early resolutions. We say in dispute resolution, the best place to resolve a dispute is as early in the life cycle of that dispute as possible. And if you can resolve it before the complainant even notifies the respondent, all to the good. A prevented dispute is a very efficiently resolved dispute. And then once you go from diagnosis, you go to negotiation. Now, mediation is obviously just assisted negotiation, but in ODR, we have this concept of the fourth party, where technology can have a seat at the table and can assist parties to be at their best while they negotiate, which maximizes the chance that they're going to be able to resolve the dispute through mutual agreement. We also have mediation processes when we bring in human mediators. And technology can give mediators enormous flexibility in having joint conversations and caucuses at the same time, or tracking issues. Maybe even the panelists can look at a big group of mediators and decide which one they want to work with. And you can also provide solutions to parties that they can consult and decide which are most relevant to them. And then the last, obviously, is evaluation. And I think Shannon talked about this as well. In the United States, only 2% of cases filed in our civil courts actually make it to a trial. Most of the cases are worked out through mutual agreement or through settlement. So we shouldn't optimize the process for evaluative outcomes when we have so much opportunity, especially through technology in the earlier phases of the dispute. So the other thing is, it's not about online or offline. I think it's interesting what Dory said. In-person hearings can be very powerful. And the 250,000 cases that we resolve with the American Arbitration Association each year, all of those arbitrations go to in-person arbitrations. But those arbitrations are only 15 minutes long, and everything that leads up to that arbitration happens online. The filing, the conciliation, and then everything that happens after that 15 minutes is also online. So you don't need to think about online or offline. That's a false dichotomy. You can build processes that utilize both, and then use the appropriate channel for each kind of dispute. So I'm not going to go through this in much detail. We have the master class where everybody's going to get to experiment with the Modria platform. But this is something called the Rectvisor that we've launched with in collaboration with an organization called HEAL, the Hague Institute for Innovations in the Law in the Netherlands. And it's built for the Dutch Legal Aid Board. And this is an end-to-end online divorce and separation platform. And it has a very sophisticated justice journey that, as I mentioned, goes from diagnosis through filing to negotiation, mediation, evaluation, and legal review. So I won't spend too much time going through it, but we built HEAL convened a wide variety of stakeholders, from family mediators, family attorneys, family court judges, but also psychologists and social workers. And they put together a lot of information that are relevant to people who are going through a divorce. So this is before they've even registered on the platform. They type in divorce into Google and they can get access to this wizard and educate themselves. But once they move in to the process and they go through a workbook, you can see the circles at the top that track all the issues that need to be negotiated and organize them. It has screening for domestic violence. It integrates tools, for instance, like a calculator. Here, this is once the room is open, the parties have the ability to draft settlement agreements in kind of a Google Docs type environment where they're both typing into templates provided by the system. You can see at the bottom, they have the ability to communicate back and forth. We also have calculators that they can use where they can put in their assets, and the platform will recommend appropriate levels of spousal support and child support. And if they want to get access to a mediator, they can click the mediator button. They can pay through the government. Then they can see the mediators who are available to take their case. We ask each side to pick two, so there's always one in common. And then the mediator will join the parties in the room and help them reach agreement by mutual agreement. They can also request an arbitration, but then the platform generates the separation plan. It goes to legal review. If the legal reviewer assigned by the Dutch Legal Aid Board says the separation plan is sustainable and it's within the guardrails of Dutch law, it's automatically filed. And then we also have an aftercare component where the parties can log into the platform after the separation agreement has already been filed to deal with other issues that emerge and then tweak the agreement as is appropriate. So I know I just went through a lot there, and I'm happy to send you these slides so you can look at them. We've launched this platform also in the UK with Relate, which is another #1 family charity there. And obviously, this is what it looks like in Dutch. We've also launched it in conjunction with BC Legal Services in British Columbia. So that's really the end of my presentation here. I hope I didn't go too far over. I believe that this technology is the best opportunity we have to expand global access to justice. This is what citizens and consumers want when they have a problem that they need to get resolved, particularly a low dollar value civil dispute. And I think that these tools and techniques, when combined with the increasing power of information and communications technology, this is what justice is going to look like for the vast majority of citizens and consumers in the next decade. As we say, ADR is alternative dispute resolution, but there's no A in ODR. Online dispute resolution is not an alternative. For many of these cases, it's really the only option available, and that's why we need to work together to make it a reality. So here's my contact information, and I'll cede my time back to Keryn.
Thanks very much, Colin. It's such an exciting vision, isn't it, when you see the Dutch way of getting a divorce. I think it's just so incredibly empowering. But when you break it down into its components, you realise how challenging it is. I mean, I try and think about VCAT matters where the parties actually get to choose which member they'd like to hear the matter. And that in and of itself would be quite an extraordinary and challenging shift to the way VCAT does business. But that's what's happening in that online forum. So the actual fundamental change around not only our role is to help people help themselves to solve their disputes, and the tools, the effort is into building the tools to enable them to do it. Whereas the effort and the way we're orientated today is in, investing in other people making decisions on their behalf. So it is really quite revolutionary, I think, when we start to explore these ODR options. And now I'd like to invite Michele, who's an economist but also a psychologist, and he's done a lot of research around what is the quality, I guess, of engagement online as opposed face-to-face. Are there pros and cons of each? And he's going to talk about the results of his research.
Hi, thank you very much for having me. I guess I'm kind of the pink poodle here in this session because I'm neither a lawyer nor a practitioner or the platypus for Australian purposes. What we are doing at our chair is online conflict resolution. So basically we work on systems which support the actual interaction process. So not the case filing, what the colleagues have talked before, but really the negotiation. And I will talk about two issues that we are mainly addressing. One is the more the psychologist part, which is the communication online. And the other one is the economics perspective, which is decision support systems. And so far, science provides, as always, a clear answer. Do the system work? Are they better? Science says it depends. So empirical research is very split on it. The first one is the psychological relational aspect, so communication. Here, CMC, computer-mediated communication, is a clear disadvantage over face-to-face, but at the same time, online mediation, online conflict resolution provides an information advantage, which also may redefine or at least change the role that mediators, arbitrators may have in the future. So, first, a few characteristics of computer-mediated communication. When you speak face-to-face, you have verbal cues, you have the intonation of the voice, you see how people look like. In many forms of CMC, these things are gone. And there are studies showing that 80% of the information during an interaction does not come from what you say, but your facial expression, how you look like, intonation, even how you dress or gender. So my girlfriend is a lawyer, actually, and when I said that I have to present in front of lawyers, she chose the suit for me, because you're in front of lawyers, dress properly. If I would have my normal clothes, it would look very different, trust me. So what happens is that this lack of social bandwidth results in reduced awareness of other people. There is more social distance, and encoding and decoding relational information is way more difficult when you communicate online. What happens is that first studies accordingly have found out that using CMC is less friendly, more depersonalized, more hostile. Interestingly enough, also more task-oriented. Based on this, early theories such as the lack of social context cues, social presence theory, media richness, they would all conclude, don't use computer-mediated communication for dispute resolution. So dispute resolution is usually highly complex. It involves a lot of relational matters, and the richer this task is, the richer the medium has to be. And in this case, it was face-to-face, don't use CMC. These were the early days, 80s, 90s. What happened a little bit later in academia was that, well, maybe they're not just right. And it's the so-called cues filtered back in theories. People tend to adapt to the medium. So the early theories would say, well, it depends on the medium, how well communication works. Actually not, it very much depends on the people, how they use it. They use new strategies to expand the medium. The most obvious one is using smileys, for instance. But the other thing is CMC takes more time. So it forces all these subtle signals you have in face-to-face communication, such as a smile, into one channel. You have to make it explicit verbally, otherwise it does not work. So the channel imposes certain constraints, but it's mainly how people are thought to use the channel. So this would be a first insight that we had in these online mediation programs, that you actually would have to teach people about how communication online works. It sounds kind of surprising, but there are subtle differences people are not aware of when talking online. So, sum up the first points. First, interpersonal. Here, CMC is worse off than face-to-face, the relational aspect. Second one, information process. It allows to review communication. It allows to rewrite emails. It allows you to calm down before you write an email, which is kind of important. And it allows you to use the decision support system, which have a potential to increase the quality of decision making, but in our experience, or at least the academic systems, they are not used in practice and not well accepted by users. So communication quality, as I said, it works, but nevertheless, online communication is way more ambiguous. So I guess you are familiar with Steven Seagal, 80s martial art movies, brilliant actor, better than Robert De Niro. So he says it's a nice offer, always having the same facial expression. You cannot put it into context as a receiver. It could mean anything. Now, what research says is people are way too optimistic and they're pretty bad in recognizing emotions online. If you write an email, your counterpart most likely is not capable of disentangling what kind of information, emotional, relational information you are delivering. Positive emotional messages tend to be perceived as more neutral, and negative relational emotional messages tend to be perceived as even worse. If you give the same email to 10 different individuals, there will be 5 opinions on their emotional content in those emails. And the point being is a message, there's a surface level, so which is what you actually say, your verbal expression. But at the same time, a message has 3 more layers. So what do you want people to do? What do you think about the relationship? And self-disclosure, what I want to communicate about myself. The point here is that all those 4 layers are implicitly contained in one single message. The most obvious one, the traffic lights are green, move, is a fact. But at the same time, by saying this, you imply something about what do you want the other guy to do. Shall he drive? Shall he drive faster? Don't let other drivers wait. It also reveals, can I have a glass of water, please? Sorry, I think it's the Australian climate, I'm not used to it. And about the relationship, what do you think about it by saying it? It could imply that you think that you're a better driver, depending on the tone of voice you are saying it. It could imply that you actually want to help the other person, depending on the tone of voice and the facial expression you're saying it. These things all do miss in computer-mediated communication. And when people say a statement, they think it was nice, you wanted to help the other one. This does not necessarily mean that the other party understands it in the same way. These things that otherwise could easily be communicated with a smile, because evolutionarily we are trained to recognize smiles and facial expressions, do not work in online communication. So 2 things are very important when you communicate online. One thing is direct expressions. So again, people think that they are way more transparent in their meaning and intent as they actually are. So explanations, paraphrasing, explicit emotional and relational statements, they're very important in face-to-face, even more so in computer-mediated communication. And the other thing is your wording. You have to choose it very, very carefully. So it's the phenomenon is called framing, when you actually have the same factual content, but you just phrase it differently. So for instance, not sleeping and awake, it's completely the same on a logical level, but the connotation is very different. So if afterwards someone walks up to me and tells me, well, I was not sleeping during your presentation, or yeah, I was awake during your presentation, factual content is very much the same. In one of the instances, I'm going to be happy. In the other one, probably not. For lawyers, probably important, threats and promises. From a linguistic, logical perspective, they are the same. If you write it down with formulas in Greek letters, a threat equals a promise. It's just that you formulate it differently. So if X, then Y. If you make a final concession, we will have an agreement. If not X, then not Y. If you don't make a final concession, we won't have an agreement. From the wording on a next level, I'm not sure whether you are familiar with distributive and integrative negotiation tactics as lawyers, expanding the pie. Is it familiar? So integrative is this whole expanding the pie strategies. Distributive negotiation is dividing the pie. And here is one study that we did in which we cheated our lab rats, our students. They were negotiating against a computer who sent messages. They always received the same substantive content, the same offers, the same money on the table. On one side, we phrased it integratively, and the other half of the people received the same thing phrased distributively. I've never had that many statistical significant results at the end, so this influenced satisfaction, economic offers, perceived quality of communication, and at the end of the day what we did was just changing a few words and how we phrased it. As a role of a mediator in the future, in terms of online mediation, maybe, just maybe, one future task is to teach people about using their words in an online communication environment. The other point we are looking at are the decision support systems. If you want to learn more in depth about it, ask John Selesnikov. He is the Signed Family Negotiator. He is one of those one of the co-organizers here. So on one hand, what you have is, if you negotiate or mediate online, is asynchronous communication. And this makes a huge difference if people have half an hour or a day time to write their reply. The next step is you have decision support systems. So what we do in our system that we use, people do a utility elicitation before they start the negotiation. So for lawyers, because we had divorced before, how much utility point would your child be worth? Sounds tragic, but you can translate it in utility points as opposed to the baseball card selection. How many utility points is the baseball card selection worth? And then the system proposes Pareto optimal solutions. So there's an algorithm behind that calculates different offers you can make, that calculates the fairness of the offer, and so on. And all of the studies, all of the studies I'm aware of is it leads to better outcome. Economically speaking, higher satisfaction, and so on and so on. What happens, at least now for the academic systems we develop, the usage and acceptance is very low. So the system that he presented before looks way more accessible to the public. Ours aren't. They are developed for and by scientists. They're not very user-friendly. They're very complex and time-consuming. The users tend to wonder what's going on in the background, complicated algorithms. And one of the most interesting findings we had, that people don't accept what the system proposes. So the negotiation is over. The system says, well, there's a Pareto optimal solution, so at least one gets better and none gets worse, and 70% of the people don't accept it. And we economists are still asking ourselves, why? So to conclude, is it better or worse? Well, it depends very much. On one hand, you have this communication problem. which you can solve, I think, by training people about the peculiarities of online communication. And on the other hand, you have this huge advantage of decision support systems coming from academia, which unfortunately so far are not used in private, non-academic settings. And I would just leave it at this. Thank you very much for your attention.
I just reflect on my teenage children's capacity to communicate online, and it's a lot more sophisticated than my capacity. And I do think that generational change will impact on, getting that nuancing right, and also I think getting just more skilled and more competent in online communication. We're going to carry on with some questions from the audience, and I know you've all got hundreds of questions, and we'll probably go, given we started a bit late, we might just go a little bit over 1 o'clock, depending on how many questions we get from the audience. So I know there's some roving mics around. Has anyone got any questions they'd like to start with? Eve?
Hi, thanks to all the speakers. I just had a question. Is it Dory? I just wondered, you said that you've kept the face-to-face hearings, and given all the other presentations, especially the last one, just wondering what you're thinking, what the thinking and policy behind that was?
Well, that is the outcome of a process that's been going on for the past 10 years in the Dutch judiciary, and also in some other judiciaries that I'm familiar with, that we've realized that we are not just dealing with legal issues, but that we are dealing with people who have problems. And in order to retain the legitimacy of the judiciary, we have realized that we need to address the problems before we actually get to the legal issues. And in a lot of cases, that means that we can actually produce a settlement instead of having to produce a judgment. And this is in fact a development that we think is so valuable that for that reason, the hearing still is an exploration. It's a conversation about what the problem really is and where the barriers are, and how maybe the parties can change their minds about their viewpoints. And if they can, that may be a potential for settlement rather than a legal outcome, which is, we know that the legal outcomes solve the underlying problem in less than half the cases. So we know that legal outcomes are not usually a solution to the problem. So that's why we think that the face-to-face hearing is actually of great value.
Just to provide a contrasting perspective, I suppose, we have no face-to-face hearings. We have mediators who work through whatever methods the parties choose. So it can be email, text, telephone conferencing, or video conferencing, based on how capable the parties are to use various communication channels and also the nature of the dispute. So we really rely on the mediator to determine that, in consideration of some of the factors that you've just heard as well, although there's definitely a big conversation to be had there too, I think. In terms of the adjudicators, though, are tribunal members who are authorized to make a legally binding decision that's enforceable as a court order. In those cases, primarily decisions are made based on written materials, unless there are credibility issues or complexities. For instance, somebody's not able to communicate sufficiently in English, and it's helpful to have an interpreter. If that's the case, then we have telephone and video conference hearings with the use of telephone interpreters. So we can get an interpreter in over 300 languages within 60 seconds, including several indigenous languages, so for free for the parties.
Any other questions?
Just a question about kind of social justice and awareness of results. And I think a lot of the law and social justice has evolved because people are aware of the issues at dispute and the outcomes of dispute. And I think in these mechanisms you're talking about a lot of closed resolution where people aren't necessarily aware of the outcomes. Can you talk a little bit about, as the technology evolves, how people in the public might have access and awareness
Who would you like to address that question to? Dory, I imagine you'd have a...
I could imagine that part of the answer you may be looking for is whether the public has access to court decisions, examples of what the general trend of court decisions actually is. I don't know how that works here, but the Dutch judiciary publishes a lot of its own decisions on our own website, about 60,000 decisions a year. And those are available, but they're not necessarily as accessible as they should be for the public to be able to actually digest them. But we're getting better at actually making the decisions themselves more accessible as well. Would that be the kind of direction you're looking for?
Yeah, so I'm not necessarily driving to an answer. I think one of the reasons people like Google is because you can find stuff on there.
Well, you can Google all our decisions.
Can I just, I think I've heard that that issue raised with alternative dispute resolution a lot, but I think it might miss the overall issue, which is that 98% of these cases are not resulting in case law anyway. 2% are. And if you look at what that 2% consists of, it consists largely of deep pockets in the civil sector, right? And so in a common law jurisdiction, that's what governs everybody, this 2% of cases that may or may not be reflective of the kinds of disputes that are out there generally. So I think it really speaks actually to the inaccessibility of that judicial process that's giving rise to limited case law, not the proliferation of ADR. The way that we're trying to address that is by we publish our decisions in the national free online database CanLII. I think there's an equivalent in Australia and the UK. But as part of the boot camp that my members had to go through, they have to write draft decisions at a grade 6 reading level. And that's really hard to do if you're a QC who's been writing for a fairly sophisticated audience for a long time. They struggled with that. And it's really their commitment to access to justice that made them persevere. And it's hard. I struggle with that, writing decisions too. But I think if you're talking about how do you make decisions readable for people, well, we can start by actually making them natural language.
Yeah, I think part of it is about the decisions, but also effectively about the process. How do I know that this is a good process for me? Mm-hmm. Is it necessarily about published case law? So I don't know, Colin, you're nodding your head if you have a...
Yeah, I have a lot of opinions about this. One of the things that I talked about before is fit the forum to the fuss. And I think we often think about dispute resolution in terms of we want to have access to quality neutrals, quality mediators, and quality arbitrators. But now what we need to do is we need to have quality systems designers that are actually designing appropriate resolution processes for each case volume. Now, this may sound weird for an advocate of ODR, but I think there are some cases where ODR is a terrible idea. And we have to design our systems to do the triage. You know, I showed you the Rectvisor platform. We do a domestic violence screening in that Q&A. And if there is any history of domestic violence, we actually take that case offline. There are some circumstances where the parties shouldn't be put through an online process. But I think the default resolution mechanism for disputes in almost every case is negotiation. The parties talk with each other and try and work it out. And they only appeal up the chain to mediation and arbitration when they can't work it out themselves. So we need to think about the whole life cycle of a dispute and figure out how we can use technology at each stage to provide the appropriate outcomes. Now, transparency is very interesting. I think it's interesting that both Shannon and Dory talked about publishing decisions. There are plenty of private ODR schemes that actually are completely transparent. The ICANN domain name dispute resolution protocol is 100% transparent. You can see all the cases filed and all the decisions rendered. So again, this is a systems design question. How transparent do we want it to be? One of the values we have in dispute resolution is that some disputes should be confidential. And it may be that there are some volumes where that's appropriate. But then there are other dispute volumes where complete transparency is appropriate. So again, we need to fit the forum to the fuss. We talk about multi-door courthouses where we have different doors for different kinds of disputes. ODR can let us build an online multi-door courthouse where not only do we have hundreds of doors or thousands of doors, we can have practically an infinite number of doors where we build appropriate resolution processes for each individual dispute as it comes in the door based on the needs of that dispute and those disputants. And I think we have to optimize the system in terms of how do we deliver fast and fair resolutions in each individual case for as many disputants as possible.
Thanks, Colin. Next question.
Thank you. Good afternoon. My name is Vivi Tan and I'm from Victoria University. My first question relates to the issue of governance in the ODR field. And the question is whether ODR requires governmental intervention to develop fully and to lessen the gap between its potential and its actual use, as some commentators have suggested that this particular gap is huge. Other commentators have also argued that perhaps the ODR field should implement its own internal governance system, lest external governance standards being imposed on it, such as we know, for example, the work of the United Nations Convention on, the UNCITRAL model rules, which are currently being drafted by the United Nations. So do members of the panels agree that the ODR field does require governmental intervention, or should we leave the field to self-regulate? And my second question is in relation to the two recent EU legislative initiatives to do with the ADR directive and the ODR regulation. Are there lessons that we can draw from the implementation of those two legislative initiatives in regulating the ODR field in the EU? Thank you.
I guess you're talking about regulating ODR in the private sector.
Correct.
Comments? Colin?
I'm full of opinions about this too, although the expert on this might be sitting in the front row of the audience there. John has just written an excellent article talking about the need for governance within ODR. There's a hot topic within the online dispute resolution field because, as I mentioned, ODR is blowing up all over the place. We have more than 150 providers around the world, and I think some people look at that and go, ugh, how can we be sure that these aren't kangaroo courts, where people are delivering really bad outcomes and unfair processes and they're not living up to the standards of practice that we have in the field? So I think this is a rich topic. How can we regulate ODR, allow for it to innovate and grow? Because one of the things that's tricky about ODR is it's tied to information and communications technology. I mean, there's a reason why I'm in the Cisco building here in Silicon Valley. There's going to be new technologies next year. And when UNCITRAL is envisioning rules that govern global online dispute resolution, they have no idea what those new technologies are going to be. So we have to have the freedom to innovate, to utilize these technologies to continue to push the frontier of quality ODR service. But at the same time, we don't want it to just be a free-for-all where citizens and consumers can't tell which provider is delivering good services and which provider is not delivering good services. So my instinct is to start with self-regulation. I think we have an infrastructure to do that through the National Center for Technology and Dispute Resolution. We have ethical standards that have been promulgated through ODR.info. And I think government should take a hands-off approach for a while as ODR grows. But I think this is something we need to pay attention to moving forward, no question.
Okay, and what about the second part of the question, which related to the EU?
Yeah, there are some interesting lessons to be drawn from that experience. I think the EU is much more comfortable with a heavy-handed public approach, a heavy-handed regulatory approach, as opposed to the United States, where we kind of let businesses do whatever they want, for better or for worse. But what they did was they passed a regulation that required all e-commerce merchants within the EU member states to notify their consumers of the availability of ODR. And then what the EU did was built their own ODR intake form that all of these consumers had to be directed to. That was, that's pretty powerful to have the government come in and pass a rule like that. What we're seeing is there's no teeth in enforcement. So a lot of the merchants are not following the regulation. So that's a problem. So I think it's going to be interesting. Let's look at the US approach and then let's look at the EU approach. I actually think the areas where ODR is being done best are places like British Columbia and places like the Netherlands. That's why you have Shannon and Dory there. Those guys, they're innovating like crazy and they're figuring out what works, and it's very agile. It's very fail fast and move forward. And I think that that's what we need to do at this stage in ODR's life.
Can I jump in and say that the whole issue, I think, of ODR and governance speaks to a much larger problem that should be very troubling, I think, for the public justice sector, which is that nature abhors a vacuum, and that's why private ODR exists. It's filling a massive gap that is resulting from the failure of the public justice system to innovate. And so as a result, people are going to private sector dispute resolution mechanisms because they can't hope to find relief from the public sector. To me, that's a failure, because we all pay for a justice system that's funded by and belongs to the public. And if we're not filling that gap ourselves, and we're now shifting the conversation to what kinds of regulatory schemes should we have for ODR privately, that points to a much more troubling conversation for me. And it's not that private ODR systems shouldn't exist any more than private arbitration shouldn't exist. But when we see it developing so largely and so massively and so quickly, it's because there's a bigger problem. It's because the public sector, the public justice sector, is not keeping up, and people have given up on it in many ways. And that's the question we need to be asking ourselves, I think.
Maybe,
Dory?
As to the EU initiatives, the EU is very active in setting up its own tools for people to use in cross-border disputes. But so far, I've tested out most of them as far as I could, and I find them extremely user-unfriendly. So my expectation is they will not be used much for that very reason. But we'll see. I mean, I'm a great one for user experience, so we'll see what happens and if people start using it. Thank you, Colin, again, for the compliments on the forwardness of the Dutch Rechtwijzer system. I mean, I have followed that project from, I think, 2007, when they were already developing the concept that has now at least reached a stage where it's useful for the public. So make no mistake, you don't do that in 6 months. It takes years and years of thinking and tweaking, and that's why it's so good now.
How long did it take, just by and by?
Well, it depends.
Depends who you're asking.
It depends where you
Dory,
start
I was not
counting.
involved in 2007. I think Modri was brought in to work on that project. We initially designed the proposal in 2013, and I think we launched it in 2015. So it's been running about a year. I think they've done about 1,000 divorces. So again, Dory is absolutely right. You don't build these systems overnight. They take a lot of time, especially to tweak and streamline. So I think a lot of people underestimate the complexity of putting together technology platforms. And they get $1 million and then they spend $1 million and they don't realize you have to continually edit and revise and evolve these systems. It's not just about building it and getting it right. The other thing is it's never right the day you launch it. You have to tweak it and fix bugs and streamline. So that's what I mean about fail forward. You've got to launch with a minimum viable product, and then you have to learn. And that's why you have to have these constant loops of feedback and user experience testing in order to get it right.
There's a good learning in that. Next question.
Hi, I had a question. I wanted to ask the panel to comment on the usefulness of ODR. Sorry, I'm down here.
Just a request. Could you stand up so I can
Oh,
see you?
of
Because that
course,
makes it
thank
much
you.
easier to understand.
Hello.
Thank you.
I'm Jenny. I had a question about that I wanted the panel to address about the usefulness of ODR, where you've got significant information asymmetry and power asymmetry between the parties in dispute and a highly regulated field. So where I'm coming from is as a regulator of, working for the regulator of the legal profession and dealing with cost disputes between lawyers and their clients. So there's a lot of regulation surrounding the information that lawyers have to give their clients, but by the same token, the lawyers have a much better idea of what a reasonable market rate is and how disputes, how matters should be costed. Is ODR useful without a fairly significant level of knowledgeable intervention by the neutral party who's trying to help resolve the dispute?
What do you think?
I think we operate in one of those areas. So with owners, corporations, there tends to be a lot of information asymmetry between the owner, who just knows they have an issue, and the owner's corporation, who may or may not have access to, probably does have access to a lot of legal help, among other things. That's one of the areas where the guided pathway system really, really helps. We didn't get to, I showed you a few snapshots in our view, but Modria's systems have that as well. I'm not sure about Dory's or others, but what it is an opportunity to give people the kind of information they previously would have had by seeing a lawyer, right? So 20 years ago, you'd sit down with a lawyer, the lawyer would say, right, here are the weaknesses of your claim, the strengths of your claim, here's really where it's probably going to end up, but I can't guarantee anything, here's how much it will cost, here are some risks to keep going. People don't have that now. So our aim in providing that information up front is to manage people's expectations, educate them, help them diagnose their problem, and then give them self-resolution options, which I think would work for any other highly specialized area too. So by way of reference, in BC, the Strata Property Act has 322 sections, each with two subsections per section, the regulations, the bylaws, and that's before you get into the owner's corporation's own documents. So we aim to get people to the relevant information in about 4 plain language questions. And then we give them a 1-pager periodically of grade 6, hopefully, information. So that's not bad, but that's a highly specialized, complex area that would be hopeless for lay people, and is hopeless for lay people to navigate themselves. So I would highly recommend expert systems to try and correct that information asymmetry, as well as highly trained neutrals, whether they're mediators or arbitrators, to help correct that asymmetry as well.
Yeah, if I could weigh in on that question too, I think Shannon, I'm 100% on the same page with Shannon. For me, those types of asymmetries are systems design questions. And you can imagine in e-commerce where you have very large corporations with lots of general counsels, very repeat players, and they're disputing with consumers that maybe have one dispute a year, or maybe one dispute every several years. So you've got to design your systems to walk people through that journey and empower the party that's disempowered by that asymmetry. I just finished a new book for the American Bar Association called The New Handshake, Online Dispute Resolution and the Future of Consumer Protection, and we have a whole chapter on asymmetries and how to combat them in systems designs. So I think that this is a crucial issue, and this, in many respects, the credibility of any ODR system is going to be based on how well it deals with those asymmetries. Because if you don't deal with those asymmetries over time, the high power, the high information parties are going to be able to use that system to their advantage. So that's why you got to think very carefully about how to combat these through exactly the kind of justice journeys and guided pathways that Shannon was speaking about.
We've probably got time for one more question. Down the back.
So we spoke earlier about, I guess, the difficulties that you have in rolling out these systems, particularly around working with people and processes. Normally that framework is predefined. How do you see the ODR processes taking on that framework or starting to define the framework moving forward as you have some success?
I'd like you to give a little more detail to the question. I find it a little hard to recognize the question behind what you're saying.
Right, so what I'm sort of saying is, I guess we're looking at the feedback loops and the success that you're having with the systems. How can you see that success defining the future of the rollout of these processes? Does that make sense?
Absolutely.
Yeah.
I'm still not sure. Maybe
I'll
you
take
can
a
give
crack
me a few cues.
I can give it a shot
Or
too.
let's Colin
Shannon, you
like
want to
to-
go first?
Unless Colin has some cues.
Go ahead, Colin.
Well, again, my goal is to be somewhat provocative with all of you, so forgive me, there's a non-lawyer speaking to a room of lawyers. I personally think that these types of resolution processes, as I mentioned, this is the new normal. This is what consumers and citizens are going to expect from their justice system. So when we talk about frameworks and expectations, it's not going to be acceptable to have a 3-month, 6-month resolution process in 5 or 10 years. People are going to expect that they're going to have easy access to resolution and that they're going to be able to get access to mediators, arbitrators, get their matters closed quickly. This is how people manage their investments. This is how people handle their health insurance. This is how people sign their kids up for summer camp. And it's not about whether it's fair or right, or et cetera, et cetera. This is just the new reality. The law is being disrupted by technology, just like medicine, just like finance, just like all the other industries. So we have a new framework now that we're going to be evaluated against. And old solutions won't measure up against that new framework. So I hope I'm getting to the nub of your question. But I think that as people get access to more and more of these systems, this is what they're going to expect.
And specifically, I agree with what Colin said, but specifically for us, we're a bit of an experiment, which is frankly why I'm here. if this was happening everywhere, we probably wouldn't be here. We're trying not to let the pressure get to us of the certainty that there are eyes watching. But the goal, part of our goal is candidly to be an experiment. Does this work? There are a lot of private sector ODR platforms. They work. This is one of the first ones, aside from Dory's, that's integrated into the justice system. And so we're being asked a lot for our data already 3 months in. I hope that that data will prove the example, that you can have an integration with the justice system, that there is a new way of doing this while still meeting your procedural fairness requirements to the public. One difference between private systems and public systems or nonprofit systems is that we can't choose our client base. Modria can. It doesn't necessarily need to work for 100% of people, Modria's platform, although they do a very good job of making sure that it is accessible. We have to. We can't leave anybody behind. And that sets a whole other level of expectation. It has to work for everybody and a level of complexity. So what I want to see at the end of, well, I hope this experiment doesn't end, but periodically is for us to take all of that data and tell a story about what works and doesn't work so that that data will be available for people trying to do this in other scenarios. The other thing I want to do is start surveying our users after they've gone through this process. I want to ask them questions, and we don't do this in the justice system. Courts don't do this typically, or tribunals. I want to ask them, did you feel respected as you went through this process? Did you understand what you were being told by staff and tribunal members? Did you understand what you had to do? If you didn't agree, even if you didn't agree with the decision, did you understand the decision? Did you understand why it was reached? I think those are fair questions for us to be asking people who go through the justice system. Whether the decision is right or wrong is a question for higher courts, but whether people's basic human dignity was respected by our own processes is something I think we should be accountable for.
Following up on the research question that was really behind your intervention, my experience right now is that there is very little interest in academia in these kinds of questions. So I would really advocate that those of you who are in academia start thinking about how to help the judiciaries and other bodies using ODR in improving what they're doing by actually doing research on particularly on the user experience, because that is it's hard for us to do that. And I also think that it's a very interesting and inspiring area to do research in. So again and again I say, researchers, please help us.
I think this notion of ODR driving us down this path of being entirely customer-centric, user-centric, recognising that the community's expectations of the way we deliver services is fundamentally changing, and we really need to be responsive to that. And that is the challenge, I think, for all of us who are trying to keep pace with how modern technologies can help us deliver justice to more people more equitably and more suited to their needs, hence delivering a better outcome for everyone. Of course, working in government, we also want to be highly cost effective in the way we do that. And I think that ODR offers all of these opportunities, which is why it's such an exciting time to be in our business. We're all in need of lunch now. Can I ask you to join me in thanking our guests? Thank you, Colin.
Thanks, everybody.
I'd like to also thank Colin for beaming in, and we might touch base with you tomorrow, just in case we need to either celebrate or commiserate.
Absolutely. I'm at your disposal, Keryn.
Thank you, everyone.